motion to amend one of the indictments, the indictment alleging felon in possession. And my understanding, the state is really seeking two amendments. One is not objected to by the defense, and that is just to change the word larceny to the word theft. And the second is objected to, and that is to add the mens rea of knowingly to the indictment itself.
That is correct.
Is that where we stand?
Yes, Your Honor.
Okay, great, thank you. Why don't I hear from the state first?
Thank you, Your Honor. So I won't address that issue of the amendment of larceny to theft. With regard to adding the word knowingly, the state is moving to amend the indictment at this point. This was an oversight on our part, clearly. We don't believe there would be any prejudice to the defendant in this case by adding that one word. The purpose of the doctrine and the case law around amendment to indictments is to ensure that the defendant has proper notice of the charge against them and the elements of that charge in order that they may properly prepare for trial. And again, that purpose also speaks to ensuring that nothing is changed at the last minute where the defendant has prepared for trial one way and then is forced to react in a different way, in a way they weren't able to prepare for. In this case, that's not so. I think it's clear from the defendant's opening and from the testimony elicited during the trial by the defendant's attorneys, nothing would have changed had that word knowingly been in place. The defendant in opening stated words to the effect of Logan had a gun. They admitted that he had a gun, which speaks to possession. In addition, there is significant evidence that has already been referenced, both through the state's questioning and the defense's questioning of state's witnesses, that speaks to the knowing element, where there are records that show that the defendant purchased the gun. That's an active, that's an affirmative step to obtain control of that gun, which speaks to his mens rea. There are also orders on Amazon for things like a holster. There's an order from a place called Brownell's for magazines that hold higher capacity or a higher capacity of bullets than were available when that gun was purchased. And those records from Brownell's and the records from Amazon are clearly linked and definitively linked to Logan Clegg, the defendant. And so I think there's nothing that would change. Counsel has clearly chosen to adopt a specific approach or strategy. Adding the word knowingly would not in any way change that. I will remind the court that prior to the beginning of the trial, there was not a colloquy, but an on-the-record discussion of the fact that the defendant was choosing to have, was choosing essentially not to bifurcate this charge, this particular charge we're talking about, and to have the evidence of the predicate offenses, those prior convictions, in evidence. And the state, because of that, felt that it was burdened to address those in its opening and has adopted its trial strategy that way. I have some case law for Your Honor on this subject. I would also lastly mention that I won't speak for counsel as to whether or not they were aware of the deficiency in the indictment, but whether they are aware or not, their ability to object to that has been waived, and that's clearly established by case law.
Their ability to object to
A deficiency in a charging document. And I get that from State versus Ortiz, 162 New Hampshire 585, which stands for the proposition that challenges to defective indictments must be raised prior to trial or deemed waived. And in that case, the indictment at issue did not include the statutory definition of a pattern for an AFSA type of offense. I have other cases that I think speak for the same proposition. State versus LaRue, L-E-R-O-U-X, that's 175 New Hampshire 204. It's a 2022 case where a challenge to a complaint in the middle of trial was found to be untimely. In that case, the deficiency was a failure to include the necessary element that the defendant in that case was previously convicted of a DWI second. And in that case, the court found that there was no, I guess the defendant didn't argue that his ability to prepare for trial was limited or that he would have prepared differently because it was clear that he was aware and conceded that he had been convicted of DWI second. And in State versus LaRue specifically, I have some language I'd like to flag for the court. The court in that case said, here, nothing in the record suggests the outcome in this case would have been different had the complaint been more specific. And again, that relates to that DWI second. And I would suggest that the same is true in this case. I have other case law from other jurisdictions that is obviously not binding on this court, but I do believe it is persuasive, so I would like to offer it. There's a case out of the Second Circuit from 2013, United States versus Jackson. That's 513 Federal Appendix 51 at page 55. And in that case, an indictment did not specifically contain the word knowingly or willfully, but was found nevertheless not to be deficient because a plain and common sense reading of the indictment put the defendant on notice of what the charges against him were. In this case, the statutory language is tracked and mirrored in the indictment. The statutory language itself does not contain the word knowingly. This is not a case where the statute itself has that word and it's not present in the indictment. So I think that is relevant as well. And I would offer United States versus United States versus Tobias as well, 33 Federal Appendix 547 at 549. That's Second Circuit from 2002. And one more, Your Honor. I think this is United States versus Woodruff, 296 Federal 3rd, 1041. 1046 is the pin site. That's an 11th Circuit case from 2002. In that case, I'm sorry, that case is relevant, but I'll just return to United States versus Jackson, which I previously cited. That case says that any error in the indictment was harmless because the proof at trial clearly established that the defendant acted with the requisite mens rea to support his conviction, in that case a Hobbs Act robbery. And so I think the same is true here, where the evidence elicited not only by the state but also by counsel on cross clearly establishes, I think without dispute, the evidence that would support a knowing state of mind. And in that case, there is no prejudice here. Nothing would have been done differently, and therefore we'd ask that that indictment be amended.
Thank you. Attorney Smith.
Thank you, Your Honor. State versus Ortiz. The problem was that pattern was alleged, but not the definition of what a pattern is. Two acts in a period of time of
The definition of pattern wasn't provided in the charge
the
itself.
pattern
Yes.
was alleged. The definition was not in Penalt. Similarly, defendant left the scene of an accident. There was a argument that it failed to allege that the defendant was in the accident. And similarly, in this case, we filed a bill of particulars on an indictment that we felt was deficient because it did not provide notice to us or the jury about the allegation, and that was in the most recent falsifying charge. Here, however, the indictment is constitutionally deficient. The charging document must allege all elements of the offense. The presentation to the jury, grand jury, must be about all three elements of the offense, and the grand jury must find by a preponderance of the evidence all three elements of the offense. We don't know what happened in the grand jury, but we know that they did not issue an indictment that was constitutionally sufficient. And in that level, very different from the explanation of the element. Sorry.
The
In that
supplying the definition of pattern. Charge.
Right. It was there, but maybe not sufficiently there.
So you're saying you don't dispute that there's no prejudice here.
Actually, we did know that the element wasn't there, and therefore it wasn't some charge that we should have to worry about.
Oh, so the prejudice is that the fact that there was a missing mens rea in the charge was something that the defense, knew about and therefore didn't have to, worry about in terms of its preparation of the case for trial.
Pretty much, yes. And I will say that we don't have to do the state's job for them. When it comes to things like definition of a pattern or left the scene of an accident, again, when we're saying the language is deficient, then we waive the issue if we go to trial without raising the issue. Here, the indictment does not allege whatsoever an element of the offense. We cannot waive a constitutional deficiency in the indictment of that nature, and I would talk about N. Ray, Alex C. at 158 New Hampshire, 525. It's a juvenile case, but the opinion goes on at 528 to say a charging document would need to allege the requisite mental state to be sufficient for an adult. And because it's an element of the offense and it's constitutionally deficient without it, and that the sufficiency of the charging document in that position was not waived.
Does it matter that the statute here, 159.3, is silent on a mens rea? And I think it was the case of Stratton where our court indicated that the mental state for this offense was knowingly. Does it matter in terms of the court's analysis in terms of whether or not this amendment is substantive or an amendment as to form, that the statute itself is silent on the mens rea?
No, because that case law said when it's silent, the mens rea is knowing. So that decision was made that without it, there's a mens rea of knowing, and here it is that mens rea is an element and must be alleged and proven.
I guess when I was looking at the case law, there's lots of discussions about, if it's an amendment as to form, it has to go before the grand jury. It's deficient. If it's an amendment as to substance, it has to go to the grand jury. If it's an amendment as to form, the court can do it as long as there's no prejudice to the defendant. I didn't see any New Hampshire case that addressed this question of whether, when an indictment does not allege a mens rea, that rendered it constitutionally deficient. I know, other than you're saying that 158 New Hampshire case, that one you just gave me, even though it's in the juvenile context, the language supports your argument there.
Yes.
Do you have any other New Hampshire cases that address an indictment that does not allege a mens rea?
I don't believe so.
I could not find any.
This was the only one that it was about the mens rea, and the word knowingly was kept out of the charging document.
I did see a lot of cases from other jurisdictions addressing this question, and it seemed like the weight of authority in other jurisdictions was that to allow the mens rea to be added or the charge to be amended. But your argument is that under New Hampshire law, that's impermissible.
And under the New Hampshire Constitution, Part 1, Article 15, as well as the requirement for a grand jury indictment on all of the elements of the offense.
Yeah, just briefly, I would add that Ortiz and LaRue being a 2022 case, do not make that distinction between errors that are of a constitutional nature or errors that are not. It simply says any objection to a deficiency in a charging document is deemed waived if not brought prior to trial. And I would agree with Your Honor, based on Stratton, that and the statutory language here, that this is very distinguishable from a situation where the statutory language said otherwise. And for those reasons, I think this is not an amendment of substance, it's an amendment of form, where there's no prejudice. The evidence at trial, I think, clearly establishes the facts that would go to that, and counsel has stated that they were aware of this and chose to do nothing. So I think it would be an elevation of form over substance to adopt the rationale that counsel is proposing. But I have one other case. I would agree with Your Honor that the weight of authority from other states does support the state. I have one, I don't know if the court is aware of it. It's a Florida case, Chicone versus state, Chicone versus state, 684 SO, I think that's Southern, second, 736. That's a 1996 case out of Florida. And in that case, the court held that the court held that knowledge of possession is generally considered a part of the definition of possession as used in criminal statutes, making possession a crime. And there was no error in failing to include that in the statutory language.
Ms. Smith.
I would like to point out, because I remembered reading and going through LaRue last night and didn't incorporate it, and then I had to remind myself why not, and it's because it was a complaint without the grand jury requirement, and complaints
are
can
treated
be.
differently under New Hampshire law.
I would agree. I think state versus Ortiz, though, stands for the same proposition.
Thank you. I'm going to give this some further consideration. I'm not prepared to rule on and I want to look at that further authority. Yes, Attorney Smith.
There's another issue that
Okay.
we discussed or had some email exchange with the state last
Okay.
night about an opinion evidence that they would like to introduce from Detective Brown that we object to.
What is that opinion?
Well, Your Honor, there has already been evidence of photographs of the Marshall Trail crime scene taken on May 20th when those two casings were recovered. There's been reference to these as well, but the FBI was present on May 10th at the Marshall Trail crime scene and took some photos themselves. Counsel had previously indicated to the state they intended to use some of those May 10th photographs. Those photographs were also the basis of the opinion of Mr. Latham, their expert photo witness, including the photos at issue here. The state intends to offer, through Detective Brown, the digital versions of a photo that he took, one from the same series from May 20th when he observed those casings, and to use that digital photo to zoom in on a particular area. We also intend to offer, through Detective Brown, one of those FBI photos from May 10th to zoom in on the same area. Detective Brown has expressed, and his opinion was turned over to counsel in discovery the day it was made, which was, I think, the first or second day of trial as he was reviewing things. He believes that in the same place in his photo, when you zoom in, that you can see the casing, you can see an object that he believes is consistent with that casing in the FBI photo. And we believe that evidence is relevant and admissible. I don't think there's any issue as to the photographs themselves. I think those are admissible. I'm not sure counsel is contesting that the photos are admissible as full exhibits. With regard to his opinion, we do believe that it is a lay opinion. It is not an expert opinion, so it would be under 701. And we believe that opinion would be helpful to the jury in that Detective Brown is one of the lead investigators on this case. He knows where the casings were. He viewed them. He took that first set of pictures, and he was able to, based on his knowledge of that first set of pictures, in reviewing those, look in the same area using the zoom function on one of the FBI photos, which is part of the investigation, and sees an object consistent with the shell casing.
I'm not sure what the objection is to that.
I object because I do not believe that it is a lay opinion. I think it's an inappropriate expert opinion. And I would like first to show you some of the exhibits have been introduced as full exhibits. Others we expect to introduce through Brown. And they are 193. I'm sorry. Some of the main ones, though, are 192, full exhibit. 191 is a full exhibit. These two exhibits are the distant shots of the bullet casings before any further, before putting the placards on. And I will give, which are still ID 1097 and 1098, which is where the placards are. And actually, I'm sorry, 1099 for ID was also there. And then the comparison photographs are not in at all. And they are what's being referred to as the FBI photographs from May 10, prior to the casing being found, but in that same general area. And I am providing you with all for ID 121, 122, 123, and 124. These are among the photographs provided to Mr. Latham. And I say among because, like I say, we have close-ups, which I don't think are relevant to the analysis of Detective Brown. But in any event, and it is the third one that I gave you with the placard. If you look at the there is a similar round-looking object right in front of number 1. And you heard the testimony of several witnesses that the casings were readily visible to the naked eye, but in trying to find them in the photograph, it was very difficult. And that is the reason that this is the subject of expert testimony, rather than, well, first I'll start with the lay opinion, sorry. We received on October 2nd a Zwicker letter that essentially describes looking at casings, photos of the casings and the placards, and then zooming in on the May 10 photos. And the quote from the letter is, he believes this object is likely the shell casing that was ultimately discovered on May 20. Detective Brown did not see any objects consistent with the second shell casing during this review. Unlike a lay opinion that is clearly acceptable, for instance, a police officer who observes somebody, or even a layperson who observes somebody and believes that they're intoxicated. That is an observation at the scene that the jury can't make. So that layperson is providing something to the jury that the jury can't do on their own because they can't see that person at the scene. It is also, sorry, going back to my writings. Certain lay opinions has to be helpful to a clear understanding of the testimony and determination, and that would include something like something that the jury would not otherwise know, but would know if they had had that opportunity. It is, I saw the person running that way and they were running really fast. A person watching that person could tell that might be fast, but they might choose to say it might be slow too, so it becomes an opinion. It's not an actual fact. Whereas police officers testifying to things like the credibility of a witness, which there are several cases on, they do that from their training experience, but it's not permitted because it actually is something more than lay opinion. This is something where it is equally available to the jury. The state actually can put those photographs up and zoom in on the photographs and make a determination if they're the same or similar, but believes that the object is likely the shell casing from the 20th is quite substantially different, and it's expert opinion. So since Detective Brown is in no better position to compare the 20th photograph, the photographs from the 10th, and remember, there is no evidence that he looked at that area on the 10th, that he's aware of the condition of that area on the 10th. He is in the exact same position as a juror. On the other hand, if he was in that area on the 10th and didn't see that casing when Attorney Ward walked by, then the likelihood is that it cannot be, and that the photograph simply is unclear which is where we go to the expert opinion. By the way, the citations that I have for the lay opinion.
What would be impermissible if the state were to take that same photograph and have Detective Brown say, yes, this is an area, I'm familiar with that area. Yes, I identify this as an area that we had searched in April, and we returned to many times in the course of this investigation. I've seen this photograph, and then while he's examining it, they say, is this a close-up of that? We're going to zoom in on that same area, and is that the same area that we're talking about? Yes, and then end there without having him say, I see something that appears to me to be a casing.
That is exactly what I said.
So you're comfortable with them doing that with
Yes.
Detective Brown?
Yes.
But not having him make the next leap and say, yes, in that, I'm going to use my laser pointer now and circle the area where I believe a casing was located.
Correct. And I will also say that Mr. Lathan will say, because the orientation of the photographs are different from the 20th to the 10th, and actually the 2 and the 10th, I think, are slightly different orientations too. Because the orientation is different, it takes more than looking at an area from one photograph. And what he did was, he clarified the photographs, not a huge manipulation, but what he could do without distorting the photographs. And then he identified fixed objects within the photograph. For instance, the root that is coming out of the base of the tree, and then there's a couple of roots that seem to be growing over that root, where are fixed objects. With those fixed objects and other objects that are in the same position, he reorients the photograph so that when you're looking at the different photographs, you're looking at the same view in the same orientation. And then he points to other things that are in one position in that orientation in one photograph that appear to be the same and have moved to a different position in the next photograph. And Detective Brown is simply zooming in, which is why I say what you said is sufficient. And
Let me ask Attorney Spicer, how is what Detective Brown's doing any different than, I take it, you could, on cross-examination of the defense expert, you use that do that same kind of thing with the expert, or just have Detective Brown zoom in on that area and say he's familiar with that area. Yes, that's the same general area, and this is a closer up version of this. But to have him say that appears to me to be a casing, how is that any different than what the jury can do?
I think the jury can certainly come to that conclusion themselves as well, but I do think it is helpful based on Detective Brown's position and the testimony he's already provided. And I would say that is exactly what we've done with several witnesses with hundreds of photos as well. Detective Gorham testified to any number of photos of surveillance from Walmart, where she said that's what appears in this photo. Those photos were admitted as full exhibits, and then she said what she saw. I think that's exactly what Detective Brown would be doing here, and that was done without objection.
I mean, it's one thing to say, this is what appears to be the same individual I saw. I've seen other things at the self-checkout line with some items. It's another thing to say, I mean, that's a significant issue in this case, whether or not the casings were there before May 20th, and when and at what point the casings were there. That's a big issue in the case.
Yes.
So to have Detective Brown offer his opinion as a law enforcement officer, isn't that trying to put the weight of his perspective behind that observation?
I wouldn't characterize it that way. I think it's permissible under Rule 701. I don't think there's any scientific, technical, or specialized knowledge required to do what he did, and based on this is part of his investigation. I think that is appropriate, and I would. It sounds like.
But isn't that the province of the jury to decide whether or not what he's looking at is a casing? I mean, and
I just think
his opinion would be a lay opinion. It sounds like.
while I do think when you zoom in on the photos it is quite clear, I do think it is helpful, given the nature of what's seen in those photos, it's helpful to guide them to the specific spot that he's talking about, because there's one spot that he can talk about in the photo that he saw, that he took. He can say, that's the casing right there. And I think it's helpful for him to explain, this is the exact same area, I believe, that is portrayed in that other photo, and there's an object there. I think it's helpful to orient the jury. I mean,
the one where he clearly sees a casing is from the May 20th photo.
correct. Yes.
And the one where he sees an object in that similar area, that's from May 10th.
Correct.
Okay. What if he just says he sees what appears to be an object in that area and does not characterize it as a casing?
I don't think that's permissible. And I'd like to cite State versus Supernal from August 17 of this year. Expert testimony is required if any inference of a requisite causal link must depend on observation and analysis outside the common experience of a juror. This is the observation, this is the analysis. I see an object there, I think is making a suggestion. And again, that is argument for the state, but it's not an appropriate opinion to give to the jury.
I mean, I don't see object as all that different from saying I see a twig or I see a leaf. You know, I think a casing is a characterization of it. That's an opinion. That's him injecting some experience to that. But you know, looking at this in this area, I see you know, something, you know, without characterizing it as a casing, I'm going to allow over the objection to that portion of it, but he can't say it's his opinion that's a casing.
Thank you, and if I may be allowed to lead him a little bit through
Yeah,
that, just to ensure
absolutely,
that it
absolutely.
comes out correctly.
Thank you.
Thank you.
Do you want a short break before we begin?
Can I hear the questions of how they'll be led?
Oh, yeah, how do you anticipate?
Not this second, I mean,
Just,
I'll have
so why don't we say if there's some question, if it's gonna be something, if the question is something along the lines of, you know, like, do you observe an object, you know, in that, yes, you know, what
I think-
object do you observe, and pointing to it, and just not, I just don't want him to use the word casing. It seems to me to be the casing in that same
And
area.
if I'm allowed to, I can instruct him not to use that word, if I may be allowed to coach him
I
on his
would
testimony.
actually like him to avoid using that word.
I will instruct Detective Brown not to refer to that object as a casing, and then I imagine I'll ask him questions along the lines of, you zoomed in on this photo that you took, you see where the casing is, describe where that object is in relation.
This is the May 20th one.
This is May
Yeah,
20th,
yes.
Describe where that shell casing that you collected can be seen in the zoomed-in portion of the frame here. Then I'll introduce the May 10th photo and zoom in, and I'll ask, is this essentially the same area portrayed as in the previous photo? And do you see the location where you observed the shell casing on May 20th? In this photo, do you see an object there, something along
Yeah,
those lines?
I understand. I understand the objection is that that's impermissible. I'm overruling that objection, I'm letting it, but just the word object.
And Your Honor,
Yes.
again, we talked about different orientations in pictures, and he's making an opinion about the same area. Same general area is okay, but to specify this is the same area is not appropriate, because
I think that will be clear from the photos that we're looking at the same portion of the ground at the base
Sure.
of the
I mean,
same
I don't want him to say this is in the exact same location or as depicted in that. If you want to say in like the same general area, that's, I understand that's fine.
General area.
But I understand that. Okay.
and even though I'm conceding, I'm not to the language once you've
I
made the
know.
ruling, I'm not conceding
No, I
the
know,
issue.
I know. Your objections, you're not withdrawing, the objection stands to that, and I'm overruling in part the objection, so I'm permitting it in that capacity. If there's any question, definitely approach, and even if we need to take a break
And
to
I-
further instruct him, if you need a moment to talk with him before we get started, I would prefer that I just so that we can.
I'll have that conversation, and if there's any questions, I'll just make them stop talking, and we can tailor it to make sure it comes out
Yeah,
right.
absolutely, absolutely. Do you want the photos back before we, does anybody want a break, short break before we get started? Yeah, absolutely. I'm good.
Let's
I'm
ask
listening.
Ken.
Thanks.
Can I ask one more thing?
Yes.
Do we have equal access to the WebEx?
Do we have equal
Because
access?
I'd perhaps like our expert to watch Detective Brown's testimony in that regard.
Oh, yeah,
Okay.
I don't think there's any, the only thing that we've tried to do is when we have bench conferences, I'm trying to make sure that we're muting it so we're not broadcasting but I think the only,
Okay.
I mean, I may be wrong, but most of the people who've been observing it remotely, I think, have been members of the Public Defender's Office, so.
Oh,
So,
I'm not watching.
I mean, from the WebEx, I know
Okay.
I know there are other people looking through the, MUR's live feed. Yeah.
Okay. Thank you.
I think these are the other.
Oh, I'm sorry.
I don't want to mess up your order. Great, thank you.